Chapter 1 Talking to the Police. The overbearing police interrogation designed to wrench a confession from a quivering suspect is an enduring, dramatic image. Though the image is largely relic of a past, police officers do question individuals in a variety of circumstances. For example, aside from seeking a confession, police officers may question an arrestee to uncover information about the additional suspects, or officers may simply seek information from people they have no intent of arresting. This chapter examines common situations in which police officers are likely to ask questions and describe the typical legal consequences both of talking to police and of remaining silent. Prosecutors can be counted on to use your words against you. Even a seemingly innocent explanation may appear to link you to a crime when the words are recounted by a police officer. Your statement to a police officer may return to haunt you throughout your entire case, from the charges to the amount of bail to the trial itself. People who have even a remote suspicion that they may be accused of a crime should never talk to the police before talking to their lawyer. Section 1. Police questions of people who haven't been taken into custody. This section deals with police attempts to question you in a situation in which you have not yet been placed in custody. These commonly include 1. On the street in-your-face questioning, 2. Car stop for traffic violations, 3. Investigatory visits to home or offices, and 4. Telephone conversations. 1. Can a police officer stop me on the road and question me even if I haven't done anything wrong? Yep. Even if an officer has no reason to suspect you or suspect that you have done anything wrong, the police officer can approach you to ask you questions and ask to search you or your objects in your possessions. So long as the officer doesn't suggest that you are legally compelled to talk or agree to a search, the officer has done nothing wrong. At the same time, a person is generally not required to answer police officers' questions or allow a police officer to conduct a search. 2. Is it a crime to refuse a police officer's request for identification? Maybe. Many states have a stop and identify law. Under these laws, if a police officer has reasonably suspected that a person engaged in criminal activity, such as the officer Under these laws, if a police officer reasonably suspects that a person has engaged in criminal activity, the officer can detain the person and ask for identification. A person who refuses to provide identification commits the crime of resisting an officer's lawful order. Also, laws typically require drivers who are stopped for speeding and similar infractions to provide identification when an officer requests it. A case example. Jones is standing outside his parked truck. Noticing that Jones fits the description of a man who took clothing from a nearby store about a half hour earlier, Officer Haridas asks Jones for identifications and questions Jones about where he's been the last half hour. Jones refuses to say anything to the officer. Has Jones committed a crime by refusing to talk? Since Officer Haridas reasonably suspects that Jones may have stolen the clothing, Jones' refusal to provide identifications would violate a stop and identify law. However, Jones has a constitutional right under the Fifth Amendment to remain silent. Jones cannot be punished for refusing to answer the officer's questions. Do you have to report a crime to the police? Generally, neither a crime victim nor a witness who seeks a crime take place has a legal obligation to report the crime to the police. Though a crime is an offense to the public as a whole, reporting is usually a matter of people's individual consciences and circumstances. However, you should be aware of the following. Laws in many states do require some individuals to report particular types of crimes. For example, teachers, social workers, and medical professionals may have to report suspected child abuse. You may be guilty of a crime as an accessory after the fact if you take active steps to conceal either the crime or the perpetrator. For more information, check out this chapter later. A few states, including Ohio, Massachusetts, and Washington, have enacted laws that make it a crime to see a felony occur yet fail to report it. Few prosecutions have taken under such laws. Can I walk away from a police officer who is questioning me? Unless a police officer has probable cause to make an arrest or reasonable suspicion to conduct a stop and frisk, a person has a legal right to walk away from a police officer. However, at the time of the encounter, there is no real way to tell what information the officer is using as a basis for his or her actions. In fact, an officer may have information that gives her a valid legal basis to make an arrest or to conduct a stop and frisk, even if the individual is in truth innocent of any wrongdoing. If that is the case, an officer may forcibly detain an innocent individual who starts to leave the scene of an interview. Common sense and self-protection suggest that people who intend to walk away from police officers make sure the officer does not intend to arrest them or detain them. A good question might be, "Officer, I'm in a hurry, I'd prefer not to talk to you right now. You won't try to stop me from leaving, right?" If the officer replies with that you are not free to leave, you should remain at the scene and leave the issue of whether the officer had a legal basis for detaining you for the court to determine at a later time. If I start to answer a police officer's question, can I change my mind and stop the interview? Yep. You can halt questioning at any time merely by indicating you don't want to talk anymore. A police officer told me that I didn't answer his question and I'd be arrested for loitering. Is that legal? In certain circumstances, it may be. Laws in many states define loitering as wandering around from place to place without apparent business, such as the person who poses a threat in public safety. Under these laws, if a police officer sees a person loitering, the officer can demand education and an explanation of the person's activities. If the person fails to comply, the officer can arrest the person for loitering. Therefore, the refusal to answer questions is only a problem if the officer has also observed the person loitering. A case example is Officer Yu dispatched to upscale Meadows after a resident calls the police to complain that a woman has been walking back and forth along the street for over an hour with no apparent purpose. From a distance, the officer observes the woman for a few minutes and he stops her occasionally to peer into the resident's backyard. And sees her stopping occasionally to peer into the resident's backyard. Believing that she may be planning a burglary, Officer Yu confronts the woman, asks for identification, and asks her to explain what she was doing in the neighborhood. The woman refuses to talk. So here's a question. Can Officer Yu arrest her? Answer. Under loitering laws in effect in many states, yep. Officer Yu had reasonable grounds to believe that the woman posed a danger to the community. Since she didn't identify herself or explain why she was in the neighborhood, the officer could arrest her had the woman responded to Officer Yu. The officer may not arrest her for loitering, however, she might just be subjected to an arrest of different purposes, such as trespass. An officer pulled me over for suspicion of drunk driving and questions me about where I'd been and what I'd had to drink. Can I be arrested for refusing to answer the questions? No. An officer has the right to conduct a field sobriety test of a suspected drunk driver, but the driver has the right to refuse to answer questions. In such situations, the validity of an arrest would depend solely on the person's driving pattern and performance on the field sobriety test.